I would like to introduce our first speaker for tonight. Mr. Moseley has graduated from George Mason University School of Law in Arlington, Virginia. He was a member of the GMU Law Review. He attended George Mason Law School together with Virginia's current Attorney General, Ken Cuccinelli. He worked with the U.S. Department of Education in Washington and at the public interest law firm Judicial Watch. He also served as a treasurer for Christine O'Donnell's 2008 U.S. Senate primary campaign, currently the executive director of the American Border Control and a private practice here also in Northern Virginia. Tonight he agreed to speak on the latest developments on the healthcare debate. So please welcome Jon Moseley.
Thank you. Well, of course, as you know, Monday, Tuesday, and Wednesday, the United States Supreme Court was deciding 4 major different issues about Obamacare. And actually, there are many more that could be litigated. There are just certain key issues that brought up. You've probably heard that normally you get 1 hour in the United States Supreme Court for appellate argument, no matter how big the issue is. But here they went 5.5 hours, which is, even they believe this is very extraordinary. And you may have heard a lot of discussion that was very encouraging. And I want to analyze that. On the one hand, I do think there was reason for encouragement, but also I want to caution and explain, and I think also point to how desperately we need constitutional conservatives like Ken Vaughn in the United States Congress. Because one of the things that struck me about the argument in the United States Supreme Court, which was released in audio a couple hours after each morning's hearing, was how much we were just arguing over crumbs. How much of the argument in the United Supreme Court was, the Cookie Monster has already eaten the Constitution, and there's just a few crumbs left that we're debating. Because so much of the discussion was about if the question is framed a certain way, then it's okay. The only way we win on this argument is if we look at it just right. If it's a tax, anything goes. If it's viewed as regulating an existing market or something like that, anything goes. And so much of the debate that went on there was trying to slice the argument in terms of how you look at it, because almost every possibility has already gone. We've already lost in terms of the ability of the Congress to do anything it wants. Now, as you probably have heard, well, first of all, the Obamacare, the Patient Protection and Affordable Care Act, was passed in this gigantic document. We all remember part of what many people had a different last straw for different people, but one of the last straws for a lot of people was read the bill. The idea of passing this legislation that nobody had read, that Nancy Pelosi said you had to pass it to find out what's in it. That for some people was just the symbol of getting involved in Tea Party and saying, this is it, our country's going off the rails. So this massive bill got passed, and then a few weeks later, maybe less than that, another major piece of legislation that adjusting it was passed. And so it's really 2 parts, and they're not entirely consistent necessarily. But there's so many different issues there. But the focus in the legal lawsuits brought by George Mason's Ken Cuccinelli, first of all, that just focuses on certain key things, which is that the individual mandate requires people to buy health insurance. And that it exceeds the power of the United States Congress to regulate interstate commerce. Now, you've heard a lot of people come out of there very celebratory, thinking that we can, it looks like we may actually win this. I want to caution you, although I do want to be optimistic, I urge you to pray, that Miss Mary, from my law school classmate here knows, when you can't necessarily tell how a case is going to turn out by the questions the judge gives during the case. A judge or a justice, especially appellate, may ask a lawyer, I'm concerned about this issue, tell me about this. It doesn't necessarily mean they're going to come down one way or another. They may want to know the answer to that, they may become satisfied by that. argument. What's going to happen now is that the justices, in fact, they started this today, is they meet together, they vote on what their initial impression is, they vote on a tentative basis, and they then divide up their various camps, and then they begin exchanging very detailed opinions back and forth, which may change, and when they get, they get the argument laid out in precise detail, it may sway the argument back and forth. So the questions that we heard so far really cannot predict what's eventually going to happen when they decide this. However, it did look very encouraging because the gut feeling was that Justice Kennedy would probably be the swing vote, and some of the toughest comments and questions actually came from Justice Kennedy when he talked about how this fundamentally changes the relationship between the government and its people, because that thinking is significant because it is either understood as, oh, this is normal, we can always do this, or there is something fundamentally different here. And his recognition that this is something fundamentally different was very strong. And so that was very encouraging that he may be the fifth vote to overturn the individual mandate. And of course then the question becomes how much of the rest of the law, or all of it, is struck down as a result. Now, what happens either way? We may need a constitutional conservator like Ken Vaughn in there to deal with part of Obamacare surviving the appellate review. We may have it completely struck down, which means then we have to decide, are some of the good things in there, or allegedly good things, or good ideas done badly, but they need to be done right, on the agenda, on the plate. And obviously we need someone who really has a compass about constitutional values and American values to navigate that very complicated storms. So let me run through. I think I want to focus on the concern of how much we're really arguing about crumbs. Congress has the power to regulate interstate commerce. About a century or more ago, there was a series of cases where we had a fairly, I don't know if conservative is the right view, a strict constructionist Supreme Court that was in the process of saying no, and then even before FDR came along with his New Deal, and the Supreme Court was saying no, you can't do that, no, and then the FDR gave us the court packing scheme, which basically said if you don't see it my way, I'm going to expand the Supreme Court from 9 to 15 justices and add 6 votes my way. And so suddenly the Supreme Court started going yes, 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 yes. Now if you sign a contract with a gun to your head and you can prove it, the law will say that's not a valid contract. You were coerced. So here we have the Supreme Court changing our country in tremendous ways with a gun to its head. And one of the most amazing examples of that is my favorite case from law school, Wickard v. Filburn. And I learned more about it recently. Roscoe Filburn was a dairy farmer near Dayton, Ohio, who grew wheat on his own farm and fed it to his cattle on his own farm. That's interstate commerce, according to our U.S. Supreme Court. Never left his farm. Now you've probably heard Ken Cuccinelli say that, and others say that if the Supreme Court says that Congress can make you buy health insurance, the government can make you buy anything. I say that's not exactly right. Because if this is constitutional, the government can make you do anything. Not just buy, but do anything. Because the argument is that if you do something that has an effect on interstate commerce, that can be regulated. So the Congress has the power to regulate interstate commerce. What you do may have some effect on interstate commerce in an infinitesimal way, but when you add it up with everybody, that has an effect on interstate commerce, so Congress can therefore regulate it, even though it's plainly not interstate commerce and possibly not even commerce. And under that reasoning, if we lose this case, there is really no limit to the power of Congress. There is no federalism. Federalism is dead. The country that our founders drafted is dead. And the states, as I've heard Ken Cuccinelli say, simply become administrative districts of one all-powerful federal government.